Possession case.
Yes, ma'am.
Good morning. Are you Anthony Whitmire?
Yes, ma'am. Good morning, Your Honor.
And Mr. Rojas, will your client with the formal reading of the indictment?
He will, Your Honor.
Mr. Whitmire, in cause number 25 DCCR 0057, you're charged with the second-degree felony offense of possession of a controlled substance from October 12th of 2024. And how do you plead to that charge? Are you pleading guilty freely and voluntarily? And are you pleading guilty because you did what they've charged you with? I have here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1. Before you sign these, did you go over them with Mr. Rojas? And do you fully understand them? And do you understand, if I follow the agreement that you've made with the district attorney, that you'll be waiving or giving up any right to appeal? Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenders number 1.
No objection.
It's admitted. Is there any evidence that Mr. Whitmire is not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily, find that you're mentally competent and you understand the nature and the consequences of your plea, find sufficient evidence to find you guilty, and at this time find you guilty of possession of a controlled substance, sentence you in accordance with your agreement to a term of 3 years in the institutional division of the Texas Department of Corrections. You will receive credit on that for any time that you've been in custody that the law gives you the right to receive. I'm going to sign a dismissal as part of this plea agreement, and clause number 25 DCCR 0056. I've handed you the trial court certification that shows this was an agreement that I followed, so you waived your right to appeal. I also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Just thinking about yesterday, and this is a possession case, so I'm not sure how it applies. But because of the judgment entered against you, you could be ineligible to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. If you have any questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Rojas and read that document carefully. All right, you can go back with the bailiff.
Thank you.
See, and so am I going to have to start modifying? I think I'm safe just saying it. And
It's like a citizenship thing, because you can't control whether it does or doesn't.
I know.
Readmitted.
But I mean, they've said specifically that possession is not one of them. In the Hambry case.
It really more says case by case, and I don't think it's such a blanket.
I would continue to give the.
I'm going to say, yeah, as I was saying it, it made me think. Okay, good morning. Are you Brendan Ernest? And Mr. Rojas, will your client waive the formal reading of the indictment in each case?
He will, Your Honor.
Right, Mr. Ernest, in cause number 26 DCCR 0429, you're charged with the first-degree felony offense of aggravated robbery, and that's from February 20th of 2026. And how do you plead to that charge? Are you pleading guilty freely and voluntarily? And are you pleading guilty because you actually did what they've charged you with? Then, let me take a second. And cause number 26 DCCR 0430. You're charged with a third-degree felony offense of obstruction or retaliation from February 12th of 2026. And how do you plead to that charge? Again, are you pleading guilty freely and voluntarily? And because you did what they've charged you with? In cause number 26, DCCR 0908, you're charged with a second degree felony offense of robbery. And that's from February 12th of 2020. And how do you plead to that charge? Again, are you pleading guilty freely and voluntarily? And are you pleading guilty because you actually did what they charged you with? In all three of these cases, I have here on the tablet some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Rojas? Do you fully understand them?
Yes.
And do you understand if I follow the agreement that you made with the district attorney that you will be waiving or giving up any right to appeal?
Yes.
So you can't change your mind if I follow the agreement. You understand?
Yes.
And it looks like the agreement that you've reached in all of these cases would be for 10-year deferred probations. There would be $500 fines in each case. There would be a dismissal in cause number 26, DCCR 0431, and you would be required to follow all the rules and conditions of probation. Is that your understanding? Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenders number 1 in each case.
No objection.
It's admitted in each case. Is there any evidence that Mr. Ernest is not competent?
No, Your Honor.
All right, sir, I'm going to find in each of your cases that you entered your pleas of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of your pleas. Find sufficient evidence to find you guilty in each case, but I'm going to reset your cases for sentencing so that the probation department can do a pre-sentence report. That'll give me more information about you and your cases, and then we'll come back later for sentencing.
Yeah.
All right, you can go back with the bailiff. You've got Vicente Gloria, Mr. Rojas.
that was restated.
Good morning. Are you Tasia 1 Mac?
Yes, ma'am.
And this is cause numbers 24 DCCR 1046 and then 26 DCCR 0085 and 0086. Mr. Mack is charged with criminally negligent homicide. And then those last two are both bell jumping and failure to appears. Mr. Smith, what is the announcement?
Got we signed,
Oh, nope.
rejection.
There it is. Sorry, they were just coming through. Let me go through then. All right, Mr. Mack. In cause number 24, DCCR 1046, you're charged with the state jail felony offense of criminally negligent homicide, and that's from March 10th of 2024. And what that means, sir, is that if you go to trial and you're found guilty in that case, the range of punishment would be between 6 months and up to 2 years in a state jail prison. Do you understand?
Yes, ma'am.
And then in cause number 26, DCCR 0085, you're charged with a 3rd-degree felony offense of bail jumping and failure to appear from December 15th of 2025. And what that means in that case is that if you go to trial and you're found guilty, the range of punishment would be between 2 years and up to 10 years in prison. Do you understand?
Yes, ma'am.
And then finally, in cause number 26, DCCR 0086, you're also charged with a 3rd-degree felony offense of bail jumping, and that's from January 5th of 2026. Same thing, if you're found guilty in that case, the range of punishment would be between 2 years and up to 10 years in prison. Do you understand?
Yes, ma'am.
In each of those cases, I have here on the tablet plea bargain rejections that you've signed with Mr. Smith that shows that the district attorney's office has made offers if you wanted to enter pleas of guilty for a 2-year term in the state jail prison on that state jail case, and then 5-year terms on the other 2 bail jumping cases, all to run concurrently or at the same time. You have every right to reject those offers and have all of your cases set for trial. I just want to make sure you understand what the possible consequences are if you go to trial, what your options are if you wanted to enter pleas of guilty. And do you understand all of that?
Yes, ma'am.
And do you want to reject those offers and have all of your cases set for trial?
Yes, ma'am.
Has everything discovery been you've gotten everything you need, Mr. S, or everything they have as far as you know?
Half, Your Honor. However, just to, this, court will know, uh, due to my hospitalization, I truly believe that these cases can be moved if we can get an offer of probation. That is, that is not the case at the moment, but, that's where we're at. Just, this is the first offender. He's eligible for probation from a jury. Right now, Mr. Coleman is only recommending print time.
Do you know, Mr. Nichols, who, is this going to be yours or are you just covering
I don't.
today?
I don't know ultimately it's going to be assigned to a judge. I know, I mean, it's a homicide case, so I wouldn't expect that part of the offer to change.
Well, except though that the witnesses are going to testify that the shooting is.
Well, that's all between y'all. I don't need to know
Okay.
what all that is.
Okay.
At this point, what I'm going to do is put it on the trial docket.
Okay.
Obviously, if something changes between now and then, I'd rather take care of it well before. So whoever gets assigned to the case, or if Mr. Coleman keeps the case, but either way, if something changes, then y'all let me know. We'll move the case up. Otherwise, we'll take a look at it again on the pretrial date. And then after that, we'll get set for trial.
Thank
Or we'll set up for trial now, but we'll discuss it again in pretrial.
Thank you.
All right,
Thank
you
you.
go back with the bailiff. Mr. LeBlanc, you've got Samuel Harmon. Good morning, sir. You're Samuel Harmon.
Yes, ma'am.
And this is cause number 25 DCCR 1019. Mr. Harmon's charged with aggravated assault with a deadly weapon. And 26 DCCR 0385 charged with assault of a public servant. And what is the announcement?
Yes, he wants to trial. I've conveyed them.
Is the offer, let's see,
Judge, he had previously rejected 15. I re-urged that today.
Okay.
This is their first appearance with this newer charge
right.
that was indicted in March. And my offer was for them to run concurrent.
So 15 years in each to run concurrent.
Yes, Your Honor.
And so when we've gone over this before, Mr. Harmon, when it was just the one case, that if you're found guilty in either of these cases, the range of punishment would be that of a habitual offender, if that prior criminal history is correct, which means your minimum punishment would be 25 years in prison up to 99 years or life. And you understand that?
Yes.
And you understand the offer of that 15 years is now for both cases to run concurrently or at the same time. You understand? And you want to go forward on both of those cases to trial. Is that correct?
Yes, I was wanting time though to hire an attorney. My people are gonna give me an attorney.
So here's what I'm going to do, just because this has been going on for some time. Obviously, if you get an attorney hired, they can step in at any time. They need to do that as quickly as possible because I'm going to move your cases to the trial docket.
Yes.
Mr. LeBlanc will begin preparation for trial. And if they get someone hired, they'll substitute in. Otherwise, he will go ahead and be prepared when that trial day comes up. Okay.
Okay.
All right.
And Judge, also that second case, I believe it could be, they try that and then you can turn around and try the next one as well.
Yes, Judge, we'd be seeking to stack.
So, Mr. Harmon, also, and I know you've gone over that with him as well, Mr. LeBlanc, that if you're found guilty in both of the cases, because those are different offense dates, that the cases could be stacked or run consecutively. If you're given a sentence in one and then they go to trial in the next, then the district attorney's office can ask me, and then it's up to me if those cases are stacked or run at the same time. Do you understand?
So it would be stacked, not concurrent.
Well, it would be up to me. So it depends on, if we go to trial on both of those cases, I would hear all the evidence in both of the cases. And if I decide that whatever sentences you're given in each of those cases, if I think they need to be stacked, then that's up to me. It's not a jury question, it's a court question. Okay, the plea agreement, if you wanted to enter a plea, is negotiated that they would run at the same time if you wanted to take the plea deal.
Oh, okay.
But if it goes to trial, then it becomes up to me if you're found guilty in both. Does that make sense?
Yes, ma'am.
Okay, and you want to go to trial?
Yes, ma'am.
All right, we'll get it set for trial. Then you can go back with the bailiff. I put him in custody, so he didn't show for the PSI, and I put him in custody so they could go do a PSI, but I didn't get any kind of update. And I didn't notice that. So this is Jason Weinberg, and we had the pre-sentence report done, but he didn't show up. So I put him in custody for them to do that part of it, and I don't show that we have that. Can you check on that for me? And I'll hold the case and see if did probation go out and talk to you? All right, I'm gonna reset it 1 week. I need somebody to get out there this week, talk to him so that we can get this taken care of next Monday, next Tuesday. Please, ma'am. All right, somebody will be out there this week. Sorry about that. Good morning, ma'am. Are you Stacy Tyler?
Yes, ma'am.
And this is cause number 26, DCCR 0800. Ms. Tyler is charged with aggravated assault with a deadly weapon. Mr. Lewis, what is the announcement?
Judge, I've been talking with Ms. Tyler, and initially I was thinking it was just some mitigating information I was gonna be getting to the state, but there is some that is material to the facts of the offense. And so I am asking for a little more time to do that, especially considering what the offer is from the state and her exposure.
Okay. And do you already have that or you're waiting to get that from?
I am waiting on a little bit of it,
Okay.
so but it shouldn't take me too long.
Okay, so I'm just gonna do a normal reset, Ms. Tyler, so that Mr. Lewis can get all of that information from you or whoever's getting that to him, get that information to Mr. Nichols, and then we'll get an announcement at the next court date, okay? You can go back with the bailiff. Janae Landerlow, Mr. Lewis,
And we're not gonna need her out.
We don't
hold on, okay.
Good.
Good morning, are you Jacoby Murphy?
No.
And Mr. Parker, will your client read the formal reading of the motion?
He will, Your Honor.
Mr. Murphy, in cause number 23, DCCR 0900, I have a motion to revoke your community supervision. Shows that you were placed on probation April 1st of 2024 for the offense of theft of property, a state jail felony. And that was, could you make sure, hold on, could you check that and make sure it's fine? Sorry. That was a 2-year term that was probated for 5 years. Is that correct?
Yes, ma'am.
And it alleges in this motion that you violated your probation. Count 1 alleges
Judge, I
that,
believe we would abandon that one. That one was not filed.
okay, just that one.
Just that one.
So we'll, count 2 alleges that you committed the offense of driving while license invalid, March 14th of 2026 in Bear County, Texas. And is that true or not true?
True.
Count 3 alleges that you failed to report to the Jefferson County Probation Department, March 10th of 2026. Is that true or not true?
True.
Count 4 alleges that you failed to gain permission from Jefferson County, to leave the county and that you were in Bear County on March 14th of 2026. And is that true or not true?
True.
Count 5 alleges that you failed to immediately report to the probation officer your arrest from March 14th of 2026. And is that true or not true?
True.
Judge, we can abandon the rest of them if you will.
All right. And so, Mr. Murphy, did you plead true to counts 2, 3, 4, and 5 freely and voluntarily?
Yes, ma'am.
And did you plead true to those counts because they're actually true?
Yes, ma'am.
I have here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them with Mr. Parker?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
And do you understand if I follow the agreement that you made with the district attorney that you'll be waiving or giving up any right to appeal?
Yes, ma'am.
State tenders number 1,
No objection.
it's admitted. Is there any evidence that Mr. Murphy is not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your pleas of true to counts 2, 3, 4, and 5 freely and voluntarily. Find those counts true, find sufficient evidence to revoke your probation, and at this time, revoke your probation, reassess your punishment in accordance with your agreement to a term of 15 months in the state jail prison. You will receive credit on that for any time that you've been in custody that the law gives you the right to receive. I handed you the trial court certification that shows this was an agreement that I followed, and so you have waived your right to appeal. I also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term. You should read that. If you have any questions about the law that prevents you from having a firearm or how long it lasts, you can talk to Mr. Parker.
Yes,
All
ma'am.
right, good luck to you, sir. You can go back with the bailiff. I tried to make it short and then I mixed it up. and made it-